Hello and welcome. I'm Peter Afrasiabi. I'm an intellectual property lawyer at the law firm 1 LLP with offices in Los Angeles and Newport Beach, California. Now, I'm actually an intellectual property litigator, and so I spend a lot of time litigating copyright cases as well as right of publicity cases. And so today's program is at the intersection of those two areas of the law. It's called voice control. And we're looking fundamentally at where copyright meets right of publicity. And we call it voice control because we will be exploring today Nancy Sinatra, Bette Midler, Tom Waits, Jennifer Lopez, and even your favorite 80s one-hit wonder, Rick Astley. And we're going to see where they take on soundalikes to try to understand where voices have intellectual property protection. So let's talk as we move forward about what the legal issues are that we're confronting today. And fundamentally, what we're looking at is the idea that brands have value because they connote a source. So we see the Nike swoosh, and we know it means they're great basketball shoes, they're great running shoes, they're just great, tennis shoes, sneakers all around. And that brand connotes a source, and it gives consumers and purchasers confidence that there's something really valuable and fantastic that stands behind it. Think Ferrari, Rolex, Gap t-shirts, you name it. All right, so the question that we have to now confront is whether really we as a people can control others' use of our voices that may sound like us. And obviously no one wants to use Peter's voice because it doesn't have any particular value. But if you're George Clooney or Brad Pitt or Jennifer Aniston, your voice has tremendous value. And if a sound-alike does a commercial and it sounds like Jennifer Aniston, me, Peter, you, the consumer, may think, wow, that's great. Jennifer Aniston stands behind this product, and so therefore I'm willing to buy the product, right? And that's the idea that we're confronting. And what we're getting at the root at is when we talk about our personal intellectual property and our persona, our personhood, what's commonly known as right of publicity, we are going to look at how far it extends beyond our name, our image, our likeness, how we visually appear, but also into more subtle aspects of personhood, such as voice. And so two sides of this equation are obviously that signature voices have great value, but also because they do, there are incentives for people to use those particular voices for commercial purposes to trade off of it. And so we will look at these through the prism of various cases. Now, this is not new in the law. At the advent of the radio and television technology age back in the 1920s and 30s, voice became suddenly particularly valuable. And we will look at cases going back to then, and we're going to look at cases from 2023. So we're going to span a full century as we look at how sound-alike technology and how technology really has triggered sound-alike issues that can be employed for good or ill. But before we get going, I want to talk about a good example of really modern technology, and we're going to look here, moving along, at Val Kilmer. And, as many of you may know, for those of you who are Val Kilmer Iceman fans from his Top Gun days, or of course Tombstone, a great movie, but that's a different story, you'll remember, and you may know, that Val Kilmer has had some significant health issues, and as a result has actually lost his voice. But maybe not, because modern technologies that are genuinely incredible allow voices to be recreated as a matter of software using really advanced sound and software technologies. And so if you watch this video here for the next minute, you're going to hear what you think is Val Kilmer, but it's actually software. So check it out.
We all have the capacity to be creative. We're all driven to share our deepest dreams and ideas with the world. When we think of the most talented creative people, they speak to us in a unique way. A phrase we often hear is, having a creative voice. But I was struck by throat cancer. After getting treated, my voice as I knew it was taken away from me. People around me struggle to understand me when I'm talking.
All right, well, there you had it. And now we're going to move along to our topics. And as you heard there, that's an example of the incredible technology that can bring Val Kilmer's voice back to life, but it also means it could be employed for ill. And so that's why as we look at our topic slide, we're going to address an overview of the right of publicity law and a general understanding of what are rights of publicity, how do they work, the substantive standards, and specifically how voices find protection in the realm of state right of publicity law. And what's important ultimately, as we'll explore, is that this is a creature, if at all, of state law. Now, we're also going to do a brief copyright overview. And copyright, of course, is the province exclusively of Congress and federal law. And so we're going to look at copyright as an overview. We are going to look at the limits that may exist coming from this exclusive federal copyright law regime that may exist to bridle or control states' ability to grant voice protection to people. And as a result, we're also going to look then at copyright preemption standards and do a little brief overview of copyright preemption to understand where, when, and how preemption may work to preempt the state right of publicity claims that people have. And in doing all of this today, we're going to hear some famous voices, we're going to see some cool stuff. We're going to start with Bert Lahr, who is the lion from The Wizard of Oz. We're going to look at Nancy Sinatra, Bette Midler, Tom Waits, Jennifer Lopez, and of course, Rick Astley, where we bring us to 2023. So moving along, let's get going, and we're going to talk now about the big picture overview of the right of publicity. Right of publicity exists as a creature of statutory or common state law, and it exists in many states, but actually not all states. And at root, what it is the right to protect against another person or entity's unauthorized use of your name, image, likeness, your persona for commercial gain. And that can include voice. Now, the root right here that we're talking about when we're talking about the right of publicity is the right really of every one of us, all of us as part of our personhood, to control commercial exploitation of our identity. And that is, in some sense, perhaps the most personal of intellectual property rights, because it really does revolve around our innate personhood and our ability to control our personhood and the use of it. What's very interesting about the right of publicity is that it exists in some states as a post-mortem right. In other words, that, for certain people whose name or likeness may have commercial value at death, and that's, for example, in California and Texas, that's a requirement that it actually have commercial value at death, then that right of publicity can survive death and be descendable. And depending on the state, it can go from 10 to 100 years post-mortem. That's why, if you think about it, you have sort of the estate of James Dean, who died, back in the 50s, still able to control his right of publicity, and so the estate's able to control the use of James Dean's name, image, likeness, voice, etc. And these rights can be very, very specific depending upon the state where someone is domiciled at the time of death. And so, if you watch my other program on dead celebrities, you can learn all about the differences in terms of the legal regimes that attach to, for example, James Dean's death versus Marilyn Monroe's death. Both died in the 50s and 60s, but were domiciled in different states, and so the outcomes are drastically different in terms of even the existence of this intellectual property right that can be descendable. And what's important to know is that some states also have registration regimes, so you need to perhaps fill out registration paperwork to register and make your claim as to the right of publicity. Moving along, let's talk about where this right came from at the common law. And this is really before codification as state positive law. And it was first fundamentally conceptualized in really the seminal work of Brandeis and Warren. And this is a very, very famous law review article that you all know about if you've watched our Bill of Rights program on right to privacy, where we explore the right of privacy. You obviously know about Justice Brandeis's famous law review article, The Right to Privacy, from the Harvard Law Review. And this is from the 1890s, and it was before he was a Supreme Court justice. But it was where he first really conceptualized what we today talk about as in terms of a right of privacy, in terms of our personhood. And so that concept then existed at common law in various states, and it took root in terms of defamation, false light, invasion of privacy. And it morphed and adapted in the common law over time in terms of being a sort of property right to protect one against passing off of one's likeness. And it then, over time, was codified as positive law in various states. In California, that happened in the 1970s. And really today, in the 2020s, it's recognized in over 35 different states, either as statutory or common law. And the key point to keep in mind here is that this is a distinct right to copyright and trademark law. Now, these rights that were bouncing around in the states actually eventually reached the U.S. Supreme Court in a seminal case in the 1970s called Zucchini versus Scripps Howard. And this is where the U.S. Supreme Court actually recognized that, yes, this right that's bouncing around in the states does exist and it is a legitimate right. And that case involved a situation where you had a famous performer, Zucchini, who was the human cannonball. And his whole act was, getting in the cannon and getting launched out and landing and surviving. And it was a 10, 15 second event. But that was his persona. That's how he made money. And so this was filmed by a news outlet. They filmed it without his consent. They broadcast it on TV. And when that gets played on TV, then Mr. Zucchini is unhappy because people aren't going to come pay to see him, do his human cannonball thing. And so he sued under Ohio's right of publicity. And the broadcasting companies claimed that they had, First and 14th Amendment rights to record it, broadcast it, publish it as news. And he brought the challenge. And over their First and 14th Amendment objections, this case went all the way up to the U.S. Supreme Court. And the U.S. Supreme Court said that no, the Constitution wouldn't act to protect the news provider, and that his state rights were abridged, and he had the right to control in that very, very short video sequence his persona. And so really this was 1977, and things exploded after then in terms of the codification of laws in different states, and then the use of these state laws by celebrities or quasi-celebrities or even non-celebrities to protect their right of publicity. So moving along, let's unpackage the right of publicity. And we'll use California really as a typical statutory right. It's an exemplary one that we can use, and it's in the California Civil Code, Section 3344. And it protects against the unauthorized use of a person's name, likeness, voice, signature, even photograph in commercial advertising. And so here you see the actual statute and the language and the prima facie case that comes from it. But the language states, any person who knowingly uses another's name, voice, signature, photograph, or likeness in any manner on or in products, merchandise, or goods, or for purposes of advertising or selling or soliciting purchases of products, merchandise, goods, or services without such person's prior consent, or in the case of a minor, the prior consent of his parent or legal guardian, shall be liable for any damages sustained by the person or persons injured as a result thereof. So what we distill from this is the fundamental prima facie case is that there needs to be a knowing use of the plaintiff's protected identity, one of those nouns you see in the statute. It must be done for advertising purposes, and there really needs to be a direct connection between the use and the commercial purpose. Now in California, for deceased, that right can last 70 years after death, and it's considered freely transferable, licensable, descendable. It's fundamentally a property right. Now in California, it descends at death only if at death the deceased person's right of publicity had, quote, commercial value at the time of his or her death. Now, other states do vary on the existence of this postmortem right, and then if it does exist, the scope of applicability, i.e. the number of years and whether it requires even the idea that it have commercial value at the time of death. Let's move along and we'll look at briefly some statutory limits that do exist, and these are not in all states, but these are in California and also New York, so this is sort of, and they're pretty exemplary, so most states have limits, somewhere in this ballpark. The first one in California is that the statute contains an explicit exception for uses in connection with any news, public affairs, or sports broadcast or account, or any political campaign. Now in California, there's also exemptions for uses in plays or books or magazines, newspapers, musical compositions, audiovisual works, radio, television programs, single and original works of art, works of political or newsworthy value, or any advertisement for any of these works. And these exemptions are built around First Amendment media ideas. In other words, someone has the right to, do a documentary on Marilyn Monroe and discuss her, talk about her, and they don't need to go get a license to her right of publicity in order to do, a play, a book, a magazine, article, whatnot on Marilyn Monroe. New York is similar, as you see here, and New York says that it's not a violation of publicity rights if a deceased personality's name, voice, signature, photograph, or likeness is used in a play, book, magazine, newspaper, or other literary work, artwork, or other visual work. Any and all uses that are part of a work of political or public interest, or a work that has educational or newsworthy value, including commentary, criticism, parody, or satire, are also protected. So it's very, very broad, and it's rooted again in the First Amendment. And New York also even goes further, and it's one of the furthest in terms of what's known as the incidental use exception. And here you have where New York provides on our last bullet point on this slide that uses that are a part of an audio or audiovisual work, radio or TV program are exempted so long as the work is fictional or non-fictional entertainment. And this carves out any use in connection with any news, public affairs, or sports programs. And this can cover uses in advertisements and commercials for each of those protected editorial uses. And so that incidental use exception is pretty broad. Moving along, we're now going to look at the perfect storm. And you all probably remember the incredible Sebastian Junger book, and it was also made into a movie. And this is, an early right of publicity case that we can talk about that it's not voice, but we're going to look at where this idea that we just talked about with respect to the First Amendment, where First Amendment expressive activity collides with commercial exploitation. So the basic story is that these were some true events in that, mammoth 1991 storm. And as a result of that storm, there were, Sebastian Junger interviewed a bunch of people, there was public information, and then he writes a book about it. And in 1997, Warner Brothers licenses, his book and makes a film based on it. And they fictionalized for drama the characters, and they noted that it was, based in part on a true story, and that certain characters and dialogue were obviously fictionalized for drama. I mean, no one had a recording of what was going on that boat in that storm, but they sort of, fictionalized it obviously for dramatic effect. In any event, the heirs of the dead fisherman who died when the boat sank, obviously, for those of you who've seen the movie, and for those of you who haven't, sorry, I just spoiled it, but go watch the movie. It really is a great movie. And the book, absolutely incredible. In any event, they sued under Florida right of publicity law. And this went up to the Florida Supreme Court. You see there in Tyne versus Time Warner, reported at 901 South 2nd, 802 in 2005. And what the Florida Supreme Court held is that the use of a deceased's right of publicity in this film based on true events was protected, and it wasn't a use of their name or likeness for advertising or commercial purposes to directly promote a product or service. And so the First Amendment fundamentally ended up protecting the filmmakers. As opposed to, for example, if some, shipping or fishing company or something wanted to take one of those fishermen's photographs and put it on a can of, tuna or whatever, or on the fishing boat to sort of advertise what a great fishing boat they have, that would be a direct commercial use. And so when you're making films, even though they at root are commercial endeavors for money, they're also entitled to broader First Amendment type protections. And so there you have a good example of where right of publicity law collides with the First Amendment, unlike Zucchini, who we saw, where Zucchini was protected because what was taken from him was, his entire show. So now let's pivot as we move along into copyright law. And we're going to talk now about, what is copyright and what does it protect and how does it work? Copyright is an exclusive creature of federal law, attaches to original works of expression that are fixed in a tangible medium. And so as we move to this slide, you can see we ask the question, what things fall within the realm of copyright? And it's things like books and other writings, music, films, photographs, artwork, software and source code even, architecture, clothing designs, even pantomimes, choreographs. It's a whole very, very broad category of subject matters can fall within the realm of copyright. And as we now move along, we're going to talk briefly about the two fundamental requirements, and that's originality and fixation. So let's talk briefly about originality you see here. Originality means it must be original to the source. And this is a very, very important concept. It doesn't mean it is original in some sense of novelty, i.e. that you are the first person to ever, create or envision this idea. That's not what it's about. It simply means that what it is that you have put down is original to you. And courts do not want to get embroiled in the merits of artistic quality type disputes. And so as a result, the law has long held that there's a very, very low threshold when we come to figure out originality. And here you see Feist versus Rural Telegraph Company. It's reported at 499 US 340. It's a US Supreme Court case from 1991 that notes that it's a minimal degree of creativity, extremely low. And so the bar is very, very low. So in other words, as you're listening to me, watching this program, you may be doodling and drawing some cool, abstract designs or flowers, and you have a copyright because it's original to you. And as minimal you may think your creativity is in those doodles, it's minimal enough to meet federal copyright law. So you not only are you getting an hour of CLE, you're actually getting some copyrights. Now, here's Justice Holmes' quote on our next slide as we move along from the Bleistein versus Donaldson Lithographing Company case. And this goes back a century before the Feist quote you just saw. It's reported at 188 US 239. This is at page 251. And here is the underlying policy. It would be a dangerous undertaking for persons trained only to the law to constitute themselves final judges of the worth of pictorial illustrations, outside of the narrowest and most obvious limits. At one extreme, some works of genius would be sure to miss appreciation. At the other end, copyright would be denied to pictures which appealed to a public less educated than the judge. And so that's the root underlying policy concept that animates the courts. It's just not the place that courts want to wade into, because who are they to figure out what's art and what's not art? Now, the twin requirement to originality as we move along here is fixation. And fixation is the requirement that your copyright creation be fixed in a tangible medium. And those are legalese, US Congress, copyright words for permanent recording of something. So you reduce to, in some permanent way, what it is you're doing. So if you're doodling right now, that pen on the paper is your fixation as it goes down. Or if you're typing in a keyboard, the typing is considered permanent fixation too. You're drafting source code, you're drawing, you're sculpting, you're painting. Now, what this also means is skywriting doesn't count because it's not permanently recorded. So if you've come up with the greatest haiku of all time that's going to make you a millionaire and you share it with the world in skywriting, you have not yet fixed in a tangible medium your original creation. So write it down first, in other words. Now, as we move along, let's take a brief gander at what are the exclusive rights under federal law. And so when you do have your copyright, you have got your original creation, you've fixed it in a tangible medium, what now can you do with it? Well, there are, several fundamental exclusive rights that Congress has given copyright owners. One is the right to reproduction, the right to make copies. One is a transformation or adaptation right, and this is the idea of the ability to create derivative works. And so by this, it means, for example, when Sylvester Stallone wrote the screenplay to Rocky, when that was adapted into a movie, the movie was a derivative work based upon the screenplay. And so that right to transform or adapt the screenplay into a movie was one of the exclusive federal rights that attaches to Sylvester Stallone and his creation of Rocky in the script. There's the public distribution right also, as well as a public performance right that attaches to a variety of different copyright subject matters, a public display right, the right to display publicly certain types of copyrighted works. And then the sixth one you see here that we have listed is a limited narrow area of what are known as moral rights. And US copyright law doesn't generally protect what are known as moral rights to works. That's more of an idea that comes from France and the European continent, other countries, England to some extent also, in terms of broader sets of protection to artists and creators as opposed to more utilitarian-based protections, which U.S. copyright law embodies. But nonetheless, the Visual Artists' Rights Act of the early 1990s was an act that Congress passed that did give limited moral rights to very, very specific types of art. So particular kinds of limited production artworks or fine art creations, there are these additional rights that are imbued in them in terms of the right to attribution and the right not to have the work destroyed. And these rights come then from 17 U.S.C. section 106 and 106A. So let's move along now and let's start diving into voices and how copyright law touches voices. Well, you can imagine it touches voices principally in the area of music. And when we think about music, we want to think about copyright in two distinct ways, because music that we're all familiar with, you're driving your car, you're listening to a song, there are actually two distinct, at least, but fundamentally two distinct copyrights that exist. One is in the actual musical composition itself, which are sort of the lyrics and the melody, think about like the sheet music and the lyrics, right? That has its own copyright, which is known as a musical composition. And then there's the actual sound recording, the artists who actually may sit down and sing that song and record the music and, fix it in a permanent form as a sound recording that we all listen to. But they're two very, very distinct copyrights, and obviously the authors of these two different copyrights often are drastically different. In the case of Lennon and McCartney, for example, and the Beatles, they wrote their lyrics and melodies, and they also did the sound recordings. But in the case of many more modern artists, the musical composition is written by others, and many of our most famous pop stars really are just sound recording artists who record other people's written lyrics and melodies. In any event, the point is each are distinct copyrights. So let's move along here and talk about soundalikes. And when we get into the area of soundalikes under federal copyright law, we look at 17 U.S.C. section 114. And this actually starts dealing with music and sound-alike type issues. And so what it says is that the exclusive rights of the owner of copyright in a sound recording do not extend to the making or duplication of another sound recording that consists entirely of an independent fixation of other sounds, even though such sounds imitate or simulate those in the copyrighted sound recording. And so this is where then federal copyright law starts putting up a barrier in terms of the ability of one who first records and fixes a sound recording of music to stop others that may be imitating or simulating those sounds. And if we want to further unpackage what this language may well mean, we can move along to our next slide and look at what the House report provided on copyright in this section 114. And this comes from House Report number 94-1476 in 1976. And what the House of Representatives said is that the mere imitation of a recorded performance would not constitute a copyright infringement, even where one performer deliberately sets out to simulate another's performance as exactly as possible. So this now helps frame section 114, and this becomes very important as we get ready to embark into our litany of voice cases to understand, how far voices can go in terms of getting protection under state law vis-a-vis these federal principles. But before we start, let's pivot and let's talk real quick here, moving on to our next slide, in terms of copyright preemption. And we're going to look at how copyright works in terms of preempting state laws. So this is 17 U.S.C. section 301A, and this is the core statute from the U.S. Copyright Act of 1976 that became effective 1/1/78, and it provides, on and after January 1, 1978, all legal or equitable rights that are equivalent to any of the exclusive rights within the general scope of copyright as specified by section 106, remember those were our exclusive rights that we've already looked at, in works of authorship that are fixed in a tangible medium of expression and come within the subject matter of copyright as specified by sections 102 and 103, whether created before or after that date and whether published or unpublished, are governed exclusively by this title. Thereafter, no person is entitled to any such right or equivalent right in any such work under the common law or statutes of any state. And so what's evolved from this in the federal courts is a two-part test. And the two-part test asks the following two questions. Does the state right that someone is claiming fall within the subject matter of copyright? And is the state cause of action equivalent to exclusive federal rights? And as you can imagine, it's easier said than done. This stuff gets very, very complicated and tricky. So let's start moving along to J-Lo. And here we're going to look at an example of how preemption works. And so this case starts involving voice and right of publicity type issues. And so here's the basic fact pattern. Jennifer Lopez had a hit song called All I Have. And in that song, she used another singer named Deborah Law. Her name and a sample of Deborah Law's song, Very Special. Now, J-Lo licensed the sample. So the underlying musical composition and sound recording, the owners of those copyrights, wasn't Deborah Law at that time. J-Lo properly licensed everything. So she had the right to sample the sound recording and the underlying lyrics and musical composition. But nonetheless, she did sample it, and she used, within the album, it actually said, feature samples from Deborah Law's recording of Very Special. In any event, Deborah Law was not happy, and so she sued in state right of publicity. And what she claimed is that the use of the sample and her name in the release was unlawful as an invasion of her privacy and a violation of her right of publicity. Now, what the Ninth Circuit held in 2006 is that this state claim for right of publicity and invasion of privacy was preempted because the subject matter of the recordings was defined by federal copyright law. And so as a result, the lawful sampling of music and the lawful use of it, and then the re-release of a new song, All I Have, that has the music in it, is exclusively, core copyright stuff. It's music, and the idea of sound recordings and how sound recordings have protection and the limits of those protections is exclusively federal province. And so there was no way to get around that. And so, if you release music and you don't want others to ever sample it or use it, don't give up your copyright, so maybe you can control the sampling. But even in the realm of fair use, if others have the right to use it in some way, once you put it out there, you're not going to be able to come back and make a right of publicity claim as against the release of a song, which itself is also just core artistic First Amendment type behavior. Moving along, let's start getting into our voice cases. And we're going to start by going back to much earlier days in Hollywood and the space of voice. And we're going to talk about Bert Lahr. And Bert Lahr had a very, very unique voice in films and cartoons. And there you see a picture of him. He was the lion in The Wizard of Oz. And so before we get into the facts of the case, let's watch real quick here, a little clip of Bert, so you can remember what really was of kind of a unique voice that he possessed in the early golden age of Hollywood. So let it roll.
I got a number 1, 2. I got a number 3, 4. I got a number woof, woof. I got a number eyes a muggin'. 1, 2, 3, 4, 5, 6, 7, 8, woof, 11, 12, woof, woof, 14, 15, woof, woof. Have you ever felt a feeling for the delta? Zaz, zaz, in the Mississippi mud. It's a treat to beat your feet on the Mississippi Basin. M-I-S-S-I-S, south in my mouth. Christopher Columbus. Oh, you rascal, yeah, man, hot dog. Well, burn my clothes. Oh, that tiger, oh, that tiger, that tiger, that tiger, that tiger.
There you have it. So, in this case, he was unhappy, and he claimed that the defendant, the Adele Chemical Company, had released a product called Lest Oil, and they'd done a commercial, and he sued them. And what he basically claimed is that and this is quoting from the actual litigation, his style of vocal comic delivery, which by reason of its distinctive and original combination of pitch, inflection, accent, and comic sounds, had caused him to become widely known and readily recognized as a unique and extraordinary comic character. And so he was aggrieved because there was this commercial that was put out, and it was a cartoon type commercial, and it had a duck in it, but without Mr. Layer's consent, there was a voice that was done by a voice actor, and it sounded exactly like him because the actor specialized in imitating the vocal sounds of particularly the plaintiff. And so he was quite aggrieved and he was unhappy. And so he filed a lawsuit for invasion of privacy and unfair competition. And so this is a very early way that rights of publicity were approached. Remember, this is before a lot of codification of actual affirmative statutory law saying that you have a right in your voice. And so before those laws were enacted, people had to look for how can I frame this within the common law at the time. And so it was invasion of privacy and also unfair competition, the idea of passing off something as being somehow affiliated or sponsored by me when it was not. And so let's look here on the next slide at what the court held. Although plaintiff asserts that the voice of the aforesaid duck, alias perhaps Mockingbird, was heard throughout the land with possibly varying legal consequences, the law he cites is on no such scale. So it's actually a very well-written opinion. It's a lot of fun to read if you go read it. And it meanders up and down. You really think you're reading a roller coaster as to who's winning or who's losing as you go paragraph to paragraph. But then the court goes on page 259 to note that even entertainers who make no claim to uniqueness do have distinctive vocal characteristics and may be thought to be recognized. But if every time one can allege that your commercial sounded like me, but not so good, and contend that the public believed, in spite of the variance, that it was, you, and at the same time believed, because of the variance, that your abilities have been declined or damaged, the consequences would be too great to contemplate. And so what they're basically saying is, we've got to be careful opening the floodgates here, because it can't be the case that every single time someone says something sounds like me, but it's not very good, that now we have litigation. And so the courts were deeply concerned about allowing the common law concepts, in play at the time to literally open the floodgates to litigation. But, as they bounced back, they noted here, plaintiff's complaint is that defendant stole his thunder in the very, very direct sense, that the commercial had greater value because its audience genuinely believed it was listening to him. And in light of the plaintiff's allegations, the court said, we can't say that there actually was no such enhancement. Plaintiff here alleges a peculiar style and type of performance, unique in a far broader sense. And so this again was at Rule 12. And so what the court was noting is, here we have someone who has a genuinely unique, as alleged, very, very distinctive performance style. And so at Rule 12, what the court ultimately held is that before going further into this matter and the possible relevancy and scope of secondary meanings that could be ascribed to his voice, we do think plaintiff's adjectival allegations should be tested in the crucible. And so basically what happened here is he was allowed to proceed with the case. This is from the circuit court, the First Circuit. And so he went forward. And so this is one of the earliest voice cases where voice found some protection in state common law. This then brings us to Nancy Sinatra, and we're going to fast forward to the 1970s. Now, this is again before California had really codified right of publicity. And this case involves Nancy Sinatra taking on the Goodyear Tire and Rubber Company. It's reported at 435 F. 2nd, 711, and it's from the Ninth Circuit in 1970. And so before we get going and we understand why it is that Nancy Sinatra sued Goodyear, let's watch the actual commercial. It's the wonder of YouTube allows us to find these great artifacts from history that are important for our educational programs here. And so let's watch right now the actual Goodyear Tire and Rubber commercial that was released that caused Nancy Sinatra to sue them. So let's watch this.
What are the hot cars wearing this year? Boots. Why boots? GT tires from Goodyear.
These boots are made for rolling wherever cars are hot. White boots GT from Goodyear. What sports cars need, they've got.
Check the specs. Built low and wide like racing tires. Low cord angle. 4 plies polyester cord. Track tested at 130.
These boots are made for rolling wherever cars are hot. White boots GT from Goodyear. What sports cars need, they've got.
If you drive a high-performance car, you need Goodyear's finest high-performance tire.
All right, there you go. It's amazing, really, how, in some sense, how bad commercials were back in the day. But nonetheless, that commercial was released, and Nancy Sinatra was very unhappy. She then filed a California state passing off claim, kind of like Bert Lahr's claim. And what she claimed is that the song and the arrangement of the song had acquired a secondary meaning, which under California unfair competition law was protectable. And in other words, what she was saying that's a lot broader than what our Lion from the Wizard of Oz was saying is that this actual song, the totality of the song and the way it's performed, functioned as a trademark indicative of Nancy Sinatra, and so it connoted her. Now you can imagine this is a much broader claim, because what this means is that there are limits on anyone else's ability to actually record the song, perform in a particular way, which are core artistic type creative endeavors. And so Nancy Sinatra wasn't just claiming that, oh, you did a commercial with a sound-alike that sounded distinctly like me to trick people. She went much broader. And as a result, here's what the Ninth Circuit held. It held that under state passing off law, Sinatra and Goodyear were not in competition in any manner. So Goodyear wasn't passing off its tires as somehow being her products, or it wasn't passing off her records as being its products. And so given the quirks of state unfair competition law at the time, the Ninth Circuit fundamentally rejected her claim and further held that her claim was treading into the realm of federal law, because there is no federal right to control one's performance that allows you to deny others the right to make musical performances. And so as a result, Goodyear was never holding out the video as being one of Sinatra herself. And what's important to note here again is that Goodyear did license. They had copyright clearances to the musical composition to be able to hire the artist, who was a kind of a sound-alike or a look-alike type group, to sing the song. So they weren't violating federal copyright law, which is why she didn't bring a federal copyright claim. And so what ultimately the Ninth Circuit held is that Sinatra was encroaching into federal law too much with her state-based theory. And so the court did this, even though it specifically noted that the voice actually did sound like an imitation of Nancy Sinatra's, but Nancy Sinatra had asked for too much in terms of trying to control the song and the performance by others, as opposed to only claiming rights in her voice. And that's an important distinction, and it's a critical distinction, because if she had only claimed rights in her voice, then she would not be trying to use the law to deny others from performing the song, singing the song, and doing musical compositions of it. Goodyear could have hired anyone to do the song, could have hired Bette Midler, who we're going to talk about in a moment. It would only be about controlling her voice. Instead, what she was trying to do was control something much broader, which tripped into federal copyright law. Now, moving along, this brings us, as we were talking about Bette Midler, it brings us to Bette Midler and the famous Bette Midler case from the Ninth Circuit in the 1980s. And this is a 1988 decision at 849 F. 2nd 460. It's coming out of the Ninth Circuit. It's Midler versus Ford, and this is when Ford had a line of cars called the Mercury Sable car. So let's watch the commercial that invoked the ire of Bette Midler. Let it roll.
Do you wanna dance and hold my hand?
Now there's a car that just asks to be driven.
You're my lover man, oh baby.
Mercury is bringing a sophisticated new shape to the American road.
Wanna dance?
Introducing Sable. Mercury, the shape you want to be in.
All right, so there you saw the 1980s commercial. I'm not sure it was much better than the one we looked at from the 1960s and early 70s, but nonetheless, that was Ford's commercial. And Ford was at the time trying to create an ad campaign for this Mercury Sable car. And Ford wanted to do something that would inspire nostalgic sentiments through the use of famous songs. And so Ford actually approached Bette Midler and said, we'll pay you. Will you sing your song? Do you want to dance for our commercial? And Bette Midler said, no, I won't. I'm not interested in my persona and my song in any way being used to, sell commercial products like Mercury Sables or Ford Sables. Now, Ford was not going to be left to its own devices, and so it really wanted to do something using her song, Do You Want to Dance? And so what it did is it went out and hired a voice impersonator, And it carried on, using the voice impersonator to make the song for the commercial. And it acquired, of course, again, just like we saw before with Bette Midler and even the Burt Lahr one, it went out and acquired the right copyright clearances to the underlying musical composition in order to re-record, with another singer the underlying lyrics and musical composition, which were not owned by Bette Midler at that time. And it did not use Bette Midler's name or her image or a picture of her or someone that looks like her in the commercial. It just had someone sing the song, "Do You Want to Dance?" which sounded just like Bette Midler. And so here's what the Ninth Circuit held. Why did the defendants ask Midler to sing if her voice was not of value to them? Why did they studiously acquire the services of a sound-alike and instruct her to imitate Midler if Midler's voice was of not of value to them? What they sought was an attribute of Midler's identity. Its value was what the market would have paid for Midler to have sung the commercial in person. The human voice is one of the most palpable ways identity is manifested. And so this is a critical holding that really affirmed massively the idea that state right of publicity protections, statutory or common law, and here it was common law in particular, find protection in terms of voice because it's a core aspect of one's personhood. Now, what the court also noted is that there are limits here. And so here you see another important quote on our third bullet point, and that is that the First Amendment protects much of what the media does in the reproduction of likenesses or sounds. And a primary value is freedom of speech and press. But, as the court held, the purpose of the media's use of a person's identity is central. If the purpose of that use of someone else's identity is informative or cultural, the use is immune. But if it serves no such function, and merely exploits the individual portrayed, immunity will not be granted. And so this immunity line that the Ninth Circuit drew here was built around the idea of, is the use something that serves an informative or cultural kind of artistic use? Or is it something that's simply exploiting an aspect of personhood for commercial profit? And so what the Ninth Circuit held is that, and it sent the case back, was that if you're trying to sell cars and you're only using a voice that sounds just like Bette Midler, you cannot do that with tripping over her right of publicity. And so what's critical here, and so this helps us now see the line between this and Nancy Sinatra, Bette Midler was not saying that the song was associated with her such that Ford could never use the song. Ford could have hired Madonna to sing the song and Bette Midler would not have had a problem. Because Bette Midler's lawyers obviously recognized the problem with the Nancy Sinatra case and how they went too far. But they went narrow to focus only on this specific aspect of right of personhood, and this helped them avoid then some preemption type issues that were lurking there nonetheless. This brings us now, we'll fast forward a little bit to 1992, and we'll have Waits v. Frito-Lay. And this is at 978 F. 2nd, 1093, and this is the famous Tom Waits case, where he took on Frito-Lay, and it's a similar fact pattern. What we have is Waits sued Frito-Lay over the use of an imitator's voice in a Frito-Lay commercial. And the imitator had actually been a cover artist of Waits, who went out and did cover work. And so commercials broadcast in 1988 on hundreds of radio stations and in multiple markets, including LA. And Waits actually heard it during an appearance on a Los Angeles radio program himself. So he's actually getting on the radio, and while he's waiting, in a commercial break, he hears a song and he says in a commercial, and he's like, "That's me," but he knew it wasn't him. So he knew immediately that anyone who heard this is obviously going to think it's him and identify Tom Waits as, sponsoring Frito-Lay's chips. Like Bette Midler, he was unhappy. Let's check out real quick. Here's a synopsis, a 1-minute synopsis. It's got parts of this is the actual commercial in Tom Waits' voice, so you can hear it and see it.
There's a new tortilla chip called Salsa Rio Doritos. It's Buffo, Bafo, Bravo, Gung-Ho, Tally-Ho, but never mellow.
Tickle your taste from the tangy tomatoes, flavor peppers, oodles of onions and sassy spices. New Salsa Rio Doritos.
Now that tongue tickler's quite a stickler. It's confounding, resounding, perplexing, complex, and involuted, convoluted, but it sure feels good. All right.
Tickle your taste from the tangy tomatoes, flavor peppers, oodles of onions and sassy spices. of new salsa Rio Doritos.
Yeah, tickle your taste. You try 'em, buy 'em, get 'em, got 'em. Everybody go up and go to Rio. Salsa Rio, everybody.
Taste of the tangy tomatoes, flavor peppers, oodles of onions and sassy spices of new salsa Rio Doritos.
Yeah, try 'em, buy 'em, get 'em, got 'em. Everybody go. You don't say so and so and so and so it goes. Salsa Rio flavored Doritos, friend. Tortilla chips. Yeah. Thank you.
So there you have it. Tom Waits sued, unhappy, he went to trial, got a jury verdict and $2.6 million in compensatory damages and punitive damages and attorney's fees. Now this went up to the Ninth Circuit, and the Ninth Circuit affirmed, and what it specifically held is that his claim, this right of publicity claim he brought, was not preempted by copyright law because the claim was for infringement of the voice only, not for infringement of a copyrightable subject matter such as a sound recording or a musical composition. So he was not trying to control the realm of copyright, sound recordings, music. That's what Nancy Sinatra was trying to do. Instead, he was protecting only his voice, and the core nature of how one's voice sounds is not within the subject matter of copyright, so the Ninth Circuit was able to say we don't have a preemption problem. And here's what they said in the last bullet point. Because the issues in Waits were whether the defendants had deliberately imitated Waits' voice rather than simply his style, and whether Waits' voice was sufficiently distinctive and widely known to give him a protectable right in its use. These elements are different in kind from those in a copyright infringement case challenging the unauthorized use of a song or recording. So if you're in copyright, complaining about the use of a song or a recording, right? The musical composition, the lyrics, the totality of the song. If that's what you're complaining about, you're in copyright, you're out of luck on a state law claim. But here he was not. And so we can see as we move along on the next slide, what exactly the court held is that then it looked at preemption was it started talking about the interplay of Section 114 that we talked about earlier. And here's what the court said. Moreover, the legislative history of Section 114 indicates the express intent of Congress that the evolving common law rights of privacy, publicity, and trade secrets remain unaffected by the preemption provision as long as the causes of action contain elements such as an invasion of personal rights that are different in kind from copyright infringement. And this is the key language that we've emphasized for you. Waits' voice misappropriation claim is one for invasion of a personal property right. His right of publicity to control the use of his identity as embodied in his voice. No preemption. And this then, with the Midler case, the Midler-Waits duo becomes sort of the core principle in our jurisprudence that buttons up and solidifies the protection of voice as a core attribute of one's personhood, one's right of publicity, that also escapes federal preemption. So this now is going to bring us to 2023, and we're going to talk about where federal law now collides with state of right of publicity law, and we're going to go back to your favorite 1980s one-hit wonder, Rick Astley. And for those of you who were MTV 1980s music generation kids like me, you will remember Rick Astley's Never Gonna Give You Up song. It was played all the time. I remember the video endlessly and the song on the radio, singing along. It was one of those great 1980s performances, and the video was that classic 1980s kind of, pastel colors and, big shoulder pads and all that. But in any event, Rick Astley has this very, very famous song from the 1980s, Never Gonna Give You Up. And what's happened in 2023 is that Rick Astley has become very unhappy because his song has been re-recorded by a modern artist using a singer and didn't have a singer who sounds just like Rick Astley. And so Rick Astley feels like Tom Waits, like Bette Midler, like Midler, like Nancy Sinatra, for example. My voice has been taken and I'm unhappy. So here are the core facts. The defendant's name is Young Gravy, and so he re-records Never Gonna Give You Up. He used a singer known as Popnik, and Popnik actually sang the song, and it's got that very unique Scottish baritone voice that's Rick Astley's voice. And they re-recorded the song. Now, Astley didn't own the musical composition to the song because he never wrote it back in the 1980s. The original lyrics, musical composition writers were someone else. And Young Gravy and the record label properly licensed the musical composition and lyrics to it, so that they had the right then to re-record it under federal copyright law. So they licensed properly, and so there was no federal copyright claim that Rick Astley could bring. But Astley was unhappy because if you hear the song, it's a Scottish baritone voice. It sounds like Rick Astley, right? And so Astley says, this is unfair. I'm like Bette Midler. I'm like Tom Waits. It's not cool what you're doing. You're intentionally mimicking my voice with someone else. You're making money out of it. You've tripped over my right of publicity. And so he files suit on that theory, claiming that the singer, the artist, and the record label had infringed his state right of publicity in his voice. This is brought in California under California state law. The name of the case is Astley versus Young Gravy. It's case number 238M-CV 00351 in the Los Angeles Superior Court. It was filed January 27th, 2023. So let's move along and see if copyright law is going to never give him up, or if it's going to give him up. And so let's talk about preemption now with the Astley case. And so here we have a great way to explore that immunity line, you remember from the Midler case and the Waits case, that really drew the line between where copyright law would preempt and stop people from being able to do things under state law versus where it would allow them to. And that immunity line for artistic First Amendment expression was one built around the idea of, is this sort of cultural artistic work being done in distinction to pure commercial uses? And if it's pure commercial use where you're just taking someone's persona for a commercial purpose, you do not have immunity, you don't have protection, and you could face liability under state law. Now here, what's different about Astley is, Astley's claim is different to Midler and Waits, because what he's claiming is that the re-recording by a Soundalike who then releases a song violates his state right of publicity. And so this is very different to Waits and Midler, because they weren't claiming that the Soundalike lacked the right to actually re-record the song. They were saying you couldn't use a Soundalike to sell a car or another commercial product, right? Potato chips, cars, computers, you name it. And it's that commercial exploitation of a voice that connotes that the voice is somehow sponsoring that product, that the courts had allowed right of publicity cases to go forward by imitator voice, even though it was an imitator voice. Here, though, the defendants in the Astley case, they're not selling, Valentine's Day flowers for 1-800-Flowers by using a song Never Gonna Give You Up. They're not selling cars or potato chips. They just released a piece of music. And so this starts getting closer to where we were with Nancy Sinatra, who wasn't complaining about a sound-alike so much as she was trying to control another's performance of a song. And Astley now squarely drops into, I would submit, Section 114 and preemption. And so you remember the Section 114 limitation that said we have to balance the rights for artists, and here we've now really triggered them. And it's a square preemption issue, really, because Astley is now trying to control another's ability to actually make a song, unlike Midler and Waits, that weren't trying to deny people re-recording songs, and they were focused instead on the commercial exploitation of a voice to sell products. Now, of course, this case as it's litigated, the argument Astley's going to make is, well, no, this song, even though it's not being used, my voice isn't being used to hawk a third-party commercial product, the song itself is commercial. And of course, at some level, that's true for all art. I mean, even, the greatest art we see from Andy Warhol is, of course, commercial. It sells for millions of dollars, right? And Andy Warhol licensed it for a lot of money. But the courts are very, very careful in terms of protecting artistic, creative endeavors like that. And even if money obviously is involved, they're not generally deemed commercial endeavors or commercial exploitations. And so this is an area where we now confront a very, very real preemption problem, because what Astley is trying to do is actually thwart a sound-alike from re-recording a song. And so you remember 114 and the House report that expressly said, you as a sound recording artist who creates something, you actually don't have a federal copyright interest in preventing imitators. Imitators have the right to imitate your sound. They can even sound really, 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 really like you. And the magnificent consequence of this is we all have our favorite cover bands, right? So that's the benefit of federal copyright law. But what it also means is because those rights have been given to imitators and those huge limits have been placed on your rights as sound recording artists, you're going to have a very hard time under preemption getting a court to bless a state claim that directly controverts and contravenes the limits of federal law in copyright. So it looks like copyright law will give up Rick Astley. Let's do a quick sidebar here before we conclude. And that's, since we've been talking so much about right of publicity and these different state rules, we need to ask the question if we need a uniform rule, because we have inconsistent rules all over the country. This leads to forum shopping. It leads to uncertainty for businesses making commercials or doing things, and uncertainty for individuals, depending upon, do I have a right if I live in Indiana versus California versus Ohio versus Alaska? What if I die? Is there a right? It's all uncertain. And so in this day and age, it starts really raising the question of whether we've reached the point that it's time for Congress to enact federal right of publicity law as to join copyright, trademark, patent, trade secrets, and the fifth, chair at the table, right of publicity. Technology is part of what's pushing the need to start really considering uniformity. And so let's take a quick look at this 1.5 minute deep fake example of Tom Cruise. Check out Tom Cruise.
That's why. Oh. It's it's a little embarrassing, it reminds me, I was once in Russia, I ran into Gorbachev. He said, Mr. Movie Star, are you nervous? I said, no, Mr. Gorbachev, I'm not nervous, I don't. He goes, well, remember how much a polar bear weighs. I said, polar bear? He said, enough to break the ice. It's the last time I've ever seen Macau Gorbachev.
What's up, TikTok? You guys cool if I play some sports? I love it. More for the audio experience. As much as the momentum. Hey, listen up, sports and TikTok fans. If you like what you're seeing, just wait till what's coming next. I'm gonna show you some magic. It's the real thing. I mean, it's all the real thing.
Okay, there you go. It wasn't Tom Cruise, but you swear it's him, right? That's how incredible the technology has become. But what it means is that celebrities and anyone, all of us, right, have huge risk down the road in terms of deep fakes being used on voice, on image, on likeness, fake porn, revenge porn, all this terrible stuff that's out there. The ability for, you may be a law firm watching this saying that I want President Obama to sponsor my law firm. Well, with, voice technology, you can do it, right? Don't do it. It's illegal. But that's the point. So it's really time, I would submit, that we start considering national right of publicity laws so that we can get ahead of the technology issues and have uniformity. That brings us to an end today. Our brief conclusions: you got a substantive overview of state right of publicity law. You had a substantive overview of copyright law and the specific federal copyright rights that exist. We looked at copyright preemption, and we specifically looked at copyright in music specifically. And in all of these, we looked at voices and where voices find protection in the law and where they don't. And remember the key fault line here for voice protection. The commercial use of a voice for profit in some sort of business venture is what gets you into trouble, as opposed to Soundalikes making music alone, which is protected. Thank you very much. As ever, if you have any questions, please email me.